Just one moment. Let me just check, make sure that everything is as it should be, and then I can get on with this next video, which is kind of slightly intensive, I must admit. Kind of heavy going, but hopefully you'll find something of interest, as I did. So this is part 8 of the looking at Brendan Dassey's appeals process. And this is looking at Judge Hamilton's, he wrote the decision, the majority decision in Brendan's case, following the en banc, the in-bench, the full panel hearing. Well, it wasn't quite the full panel. There should have been 9 judges, but 2 of them couldn't be bothered, couldn't be asked to do anything for Brendan. So they decided they were going to wash their hands of it straight away. So here we go with the 7th Circus. I use the word circus deliberately, as you know. 7th Circus decision against Brendan. So let me just do this. Hi, Sharon. We'll just do this, and let's have a look at the 7th Circus en banc decision. I say I don't use the words lightly. They are a circus, as I'm sure anybody that's been following this case can agree with. So here we go. Let's do it this way. In the United States Court of Appeals for the 7th Circuit, whatever. Brendan Dassey versus Michael Dittman. Appeal from the United States District Court for the Eastern District of Wisconsin. Well, we've got William Duffin at the top there, but he never got to say any more about it. This was argued September the 26th, 2017, and decided December the 8th. And it was before Judges Wood, who was Chief Judge, Easterbrook, Kahn, Rovner, Williams, Sykes, and the wee, let's just call him the Scottish word turd, the wee turd, Hamilton. Hamilton, circuit judge. Petitioner Brendan Dassey confessed on videotape to participating in the 2005 rape, murder of Teresa Holbach and the mutilation of her corpse. The Wisconsin state courts upheld Dassey's convictions for these crimes, finding that his confession was voluntary and could, and it says here, circuit judges Florman Barrett did not participate in the consideration or decision of this case. Why? We don't know. I think one of them decided that they had a conflict of interest, and I think the other one just was retiring, ready to get to. Finding that his confession was voluntary and could be used against him. The principal issue in this habeas corpus appeal is whether that finding was based on an unreasonable application of Supreme Court precedent or an unreasonable view of the facts. See 28 United States Supreme United States Supreme Court 2254. Whether Dassey's confession was voluntary or not is measured against a general standard that takes into account the totality of the circumstances. See Withrow versus Williams, 1993. Gallegos versus Colorado, 1962. See also Fair versus Michael, 1979. Admissibility of juvenile confession. Some factors would tend to support a finding that Dassey's confession was not voluntary. Even Hamilton can see. I can't help thinking about this statement by Seth Waxman Not a single judge thinks that Brendan is guilty. Some factors, overwhelming factors, let's put it that way, Hamilton, overwhelming factors would support a finding that Dassey's confession was not voluntary. His youth, his limited intellectual ability, suggestions by the interrogators, not just suggestions, their assurances to a vulnerable suspect that agreeing with them would produce leniency and inconsistencies in Dassey's confession. No, it wasn't a confession. That wasn't a confession. Come on, Hamilton. No way was that a confession. Many other factors, however, point toward a finding that it was voluntary. What a load of baloney. Okay, so such as Dassey spoke with the interrogators freely. Well, yes, he did. He did because he had nothing to hide. After receiving and understanding Miranda warnings, well, he received them. Did he understand them? No. And with his mother's consent? No. The interrogation took place in a comfortable setting. Wow. So that really makes a difference. That really makes his confession voluntary, because it was a comfortable setting without any physical coercion or intimidation. I don't think you were watching the same thing I was watching. Without even raised voices. They didn't need to raise their voices. That was the whole point of it. And over a relatively brief time. Which, yeah, for some people, a relatively brief time. But for Brendan, would have seemed like ages. And what's this nonsense? Dassey provided many of the most damning details himself in response to open-ended questions. On a number of occasions, he resists. Now, let's just go back to it. Provided many of the most damning details. You on about the fact that apparently Teresa was begging for her life. She wasn't even there, pal. Brendan just went along with what Bert and Ernie were putting in his mind. On a number of occasions, he resisted the interrogators. No, he never did. Strong suggestions and particular details. No, I'm sorry, dude, but you're going to have to check the other dude, the main dude, the Earl Duderino. He's going to tell you about the control question. He's going to point out you are completely wrong on this one, pal. Also, the investigators made no specific promises of leniency. After the state courts found the confession voluntary, which they would, a federal district court and After the state courts, it was not just the state court, it's also the appeals court that did absolutely a shocking review of Brendan's case, as we discovered. What was it, about 13 pages, 2 paragraphs on his, they listed his age and his intellectual and the fact he was at school. Even you said you would have liked more. A federal district court, obviously, Duffin, who was excellent, and a divided panel, because you were a member of the divided panel of this court, found that the state's court's decision was unreasonable and that Dassey was entitled to a writ of habeas, was and is still entitled to a writ of habeas corpus. We granted en banc review to consider the application of the deferential standards of 28 USC statute 2254D and the implications of the panel decisions for interrogations of juvenile suspects. The state court's finding that Brendan's confession was voluntary was not beyond fair debate. But we conclude it was reasonable. We reversed the grant of Dassey's petition, Brendan's and Stephen Law's petition, which they had won fair and square, but you decided that you would reverse it for a writ of habeas corpus. Why? I think we all know why. I think we all know why you reversed it. Because Making a Murderer came out, and it made everything. It as Steve Drizzen famously said, it's become too much of a heater. Okay, let's carry on. Oh, calm down. Part 1 provides an overview of the applicable law. Part 2 sets forth the relevant facts about Teresa Halbach's murder, Dassey's confession, and the court's proceedings. Part 3 applies the law to the relevant facts, keeping in mind the deference we must give under 2254 to state court decisions, as to which reasonable judges might differ. Reasonable judges. That's a very, very questionable term, Hamilton. So, the applicable law. We first discuss our standard of review under the Anti-Terrorism and Effective Death Penalty Act of 1996, EDPA, and then describe the Supreme Court's clearly established law for when a confession, particularly a confession by a 16-year-old like Brendan, is deemed voluntary and admissible. Part A, deference under EDPA. In considering habeas corpus petitions challenging state courts' convictions, our review is governed and greatly limited by AEDPA, Hicks versus Hepp, 7th Circuit, 2017. The standards in 28 U.S.C. 2012 was designed to prevent federal habeas retrials and to ensure that state court convictions are given effect to the extent possible. I would say given full effect to the extent possible under law. Quoting Bell versus Cohn, 2002, section 2254 provides that a state court conviction cannot be overturned unless the state court's adjudication of a federal claim on its merits, 1, resulted in a decision that was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, or 2, resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. The decision federal courts is the last reasoned state court decision. The decision federal courts look to is the last reasoned state court decision to decide the merits of the case, even if the state Supreme Court then denied discretionary review. Johnson versus Williams, 2013. In this case, we look to the Wisconsin Court of Appeals decision that Brendan's confession was voluntary. The standard for legal errors under 2255 was meant to be difficult to satisfy. Harrington versus Richter, 2011. The issue is not whether federal judges agree with the state court decision or even whether the state court decision was correct. Then what the hell are you doing? If your issue is not to find out whether a state court decision was correct. The issue is whether the decision was unreasonably wrong under an objective standard. That is just nonsense. Williams versus Taylor, majority opinion of O'Connor J. Let's just read this bit that he's got put here. Let's put this bit up. On October the 13th, 2017, the Supreme Court heard argument in Wilson versus Sellers, where one question is whether federal courts in habeas cases should continue to look through state Supreme Court summary decisions on the merits of the last state court decision that provided an explanation. See generally Hitson versus Chapman, 2015. Ginsburg J, concurring in denial of certiorari. If the court holds in Wilson that federal courts reviewing a state Supreme Court summary denial of review should give the state courts the benefit of any merits rationale the record could support, our review would become even more deferential, so the outcome here would not change. Put another way, we ask whether the state court decision was so lacking in jurors' justification that there was an error well understood and comprehended in existing law beyond any possibility for fair-minded disagreement. Richter, 562 US at 103. The existing law that applies is limited to that of the Supreme Court of the United States, which has instructed the lower federal courts to uphold a state court conviction unless the record cannot, under any reasonable interpretation of the court's controlling legal standard, support a certain ruling. Panetti versus Quarterman. Even if we were to consider the approach in past Supreme Court decisions outmoded. What do you mean, even if we were to consider the approach in past Supreme Court decisions outmoded? Of course it's outmoded, as the sensible people suggest. A state court's decision consistent with the Supreme Court's approach could not, according to you, Hamilton, be unreasonable under AEDPA. As a result, federal habeas. Okay, this is the important bit. This is what we need to get to. As a result, federal habeas relief from state convictions is rare. Okay, don't see why, but if you're telling us it is reserved for those relatively uncommon cases in which state courts veer well outside the channels of reasonable decision-making about federal constitutional claims. One wonders how far you have to veer outside the channels. AEDPA deference is not conclusive, however. Where the record shows that state courts have strayed from clearly established federal law, we can and do grant relief. For example, Richardson versus Griffin, 2017. Oh, so Judge Hamilton, you're saying that we, where the records show that from clearly, we can and do. So you can and do grant relief. For example, Richardson versus Griffin. So you actually did that, did you? You gave relief to Richardson versus Griffin, and Jones versus Callaway, and McManus versus Neal. I wonder. Shaw versus Wilson, Harrison versus Thompson, Jones versus Basinger. That's an interesting question, isn't it? He's saying that we, he's using the term we to include him. Let's have a look at this. Let's have a look at this a bit further. Let's have a look at this. Here's this statement that he's made. As a result, federal habeas relief from state convictions is rare. It is reserved for those relatively uncommon cases in which state courts veer well outside the channels of reasonable decision-making about federal constitutional claims. AEDPA deference is not conclusive, however, where the records show that the state courts have strayed from clearly established federal law. I'm right, aren't I? I can see the word we, meaning him and some other judges. We can and do grant relief, e.g. Richardson versus Griffin. Okay, Judge Hamilton, let's have a look at Richardson versus Griffin. What did we decide in that case? Oh, hold on a sec. Richardson versus Griffin, you had absolutely fuck all to do with that case. It was before Wood, Ripple and Rovner. How is that a we? How is that a we? How the hell can you claim that was we, as if you take credit for that? Stop and have a think about that, folks. Just what he's written. Let me go back to that other one, because this really does get on my nerves, this. He is such a pompous prat. We can and do grant relief. e.g. Richardson versus Griffin. Richardson versus Griffin, nothing to do with him before Wood, Chief Judge, Ripple and Rovner. Okay, let's have a look at your next one that you quoted. The next one you quoted was Jones versus Callaway. We can and do grant relief, Jones versus Callaway. Let's have a look. Let's have a look at Jones versus Callaway. Guess what, folks? Guess what? He had fuck all to do with that one either. Easterbrook, Rovner and Sykes. Nothing at all to do with you, Hamilton. You are a complete and utter prat. So look at the next one. McManus versus Neal. This is going back to McManus versus Neal, 2015. Let's have a look. Let's have a look. What do you reckon, folks? What do you reckon, folks? McManus versus Neal. Well, would you believe it? Before Wood, Florm and Sykes. Nothing at all to do with Hamilton. In fact, I'll tell you, folks, you've got to go right back. You've got to go right back. You've got to go right back to 2013, Sean versus Wilson, to find a case in which Hamilton does what he says that he did because we can and do grant relief. Now, you got to go right back to McManus versus Neal. Hold on a sec. McManus versus Neal. That's 2015. Sorry, I've got to go back. Next one. There we go. 2013. Shaw versus Wilson. Finally, we get a case in which Judge Hamilton gave his opinion. But do you know what, folks? It wasn't him that wrote the opinion. I'm going to leave it there because, as I say, it's just getting me so angry thinking about this absolute piece of shit called Hamilton that is doing this. I've got the Shaw versus Wilson. I'm going to show it to you. I've got it all lined up, ready to go. I'm going to save this one for tomorrow. As I say, we've only got to look at the bottom, the very bottom, to see that it wasn't him that wrote the decision anyway. He was just part of the panel. He finally, or way back in 2013, he actually agreed with giving somebody habeas corpus relief that Brendan was seeking. And I tell you what, it's going to be interesting, isn't it, to have a look at this case and see just how bad it had to be. Just how crass and absurd a case had to be for Hamilton to finally decide that he was actually going to get his finger out of his backside and do something. Anyway, I'll catch you again soon, folks. Bye for now.